Joining him tonight in this discussion is the director of the Center for Legal and Judicial Studies, John Malcolm, who has a distinguished career himself in law, in government, and now as the director of this center here at the Heritage Foundation. John, I'll turn it over to you. Please welcome John Malcolm.
Thank you. Justice Thomas, it's a real pleasure and a privilege to be here on the stage with you. Congratulations on being on the court for 25 years. I'd like to begin our conversation with perhaps some reflections on those 25 years. What surprised you the most about your time on the court?
Well, first of all, let me, John, can you all hear me? Yeah, because I'm having trouble hearing myself. But I'd like to thank General Meese for the introduction. I think I've grown up. I met General Meese in December 1980, and I consider it a distinct honor to have served with you in the Reagan administration and to have known you now for over 35 years. And that holds true also for Ursula. I just think that I remember when you were being criticized heavily, and that's an understatement in the city, your demeanor, your pleasant demeanor never changed. Your positive attitude, your willingness to talk to young people and to persuade them to your ideas, but not returning it with fire with fire. That has much to commend itself and much to admire. So thank you, Ed, not only for the years together, but for your example. First of all, and I also like to thank Heritage, Ed Fulner, and all the Senator DeMint, all who were involved with this evening. Of course, my wife and I made lots of trips here when she was working here, and would just love being around her. So come over here and see her. So, but I don't spend a lot of time thinking back over the time. We're too busy doing our work. I'm not a navel gazer. I mean, that's just we've got enough navel gazers in the society. We have, I think over the last few years, some things have happened at the court, certainly last year, that changed the way that we work, and we have to be focused on that. Now, maybe there were things you were thinking of talking about, but if I reflect back on the years, the thing that I enjoy most are my law clerks. Love my law clerks. They make it fun. It's the energy. I mean, the first year was really tough. I don't know how we survived that, but but I see those clerks today, and the affection you have for them is just tremendous because they were there at the beginning when we didn't have systems, we didn't have computers, when we had 4 cases a day. But through the years, I think I have to say the consistency, the effort to have a consistent judicial philosophy, and when you can't, try to explain why you've changed. I think you owe that to people. Try to make the work understandable, to make it make sense. And when it doesn't make sense, to try to point out why you think it doesn't make sense. Say something like the dormant commerce clause. So it's sort of like a hibernating bear or something. And it just says, if you can't explain it, you should at least tell people why you can't. And if it doesn't make sense, I think, as my granddaddy used to say, boy, it don't make sense because it don't make sense. But we try to make it accessible. One of the fun times for me, I think there are things that are not, in this city, I think they really enjoy themselves. I don't know. But, we were on one of our road trips with my law clerks, and this gentleman comes up to me, And he's excited. He runs up. We were at Gettysburg, and he runs up Little Round Top, and he's really perspiring. It's like June,
It's not a Civil War reenactor?
Oh, no, he's just a guy. And he's running, and he runs me down, He has this fake parchment paper with an opinion on it. I need you to sign this. I'm glad I caught up with you. I said, whoa, what is this? He said, it's your Federal Maritime Commission opinion. I said, well, why are you here with that? He said, that's what this is all about. But he said, I want to thank you because I could understand what you were saying. And he said, I read all your opinions because I can understand them. I think we are obligated to make the Constitution and what we write about the Constitution accessible to our fellow citizens.
So I assume that empowers people by giving them a sense that the Constitution is really theirs and ought to be accessible.
Well, it is theirs, and I think we hide it from them when we write in language that's inaccessible. I mean, if you think about it, I had a buddy of mine who was a wonderful, wonderful friend who was quadriplegic. And I remember before you had curb cuts, a curb that high, 2 or 3 inches high, was like the Great Wall of China.
Right.
I mean, he was that part of the city or building was inaccessible to him. And I think sometimes we make something that should be accessible. Today, of course, we have made the curbs flush with the street, so it's accessible. Well, we can kind of do that with language, too. One of the things I tell my law clerks is that genius is not putting a $2 idea in a $20 sentence. It's putting a $20 idea in a $2 sentence without any loss of meaning. But that takes work. And it takes organization and editing, et cetera. But I think the citizens, we owe it to people to present to them their Constitution in a way they can understand, to enfranchise them constitutionally.
So you mentioned that that you take your clerks to Gettysburg, and I was curious about that. Why do you do that, and what are some of the experiences or reactions you've gotten from them when you've done that?
They're polite. It's actually, I was going to stop doing it, and there was some resistance to discontinuing the trip. I really enjoy it. And I read Battle Cry. I think to understand the 14th Amendment in particular and the post-Civil War era, you have to understand the Civil War first. And you have to understand our history. That started actually when I was at EEOC. I wanted to understand the founding better, and I hired a couple of guys, young men from Claremont, John Marini and Ken Masugi. And I wasn't planning on being a judge. I just wanted to understand our founding. And as a part of that, you read Civil War history, you read the Lincoln-Douglas debates, all sorts of things. And I thought it would be important for my clerks to go, not just talk about the 14th Amendment, not just talk about the Equal Protection Clause, not just talk about substantive due process, but to go and feel it, to see the place, to see why. What was this about? Why did people die? To go where Lincoln delivered the Gettysburg Address, where he sort of implores us to the living, to make it worthwhile. There's this experiment, these people who'd given the last full measure. And also, it's the end of the term. And at the end of the term, you can be a little bit upset. And people can become, these kids can see how the sausage is made and become a little bit cynical or a little bit jaded. And I always thought it was a great idea to go and to have them see it wasn't about winning an argument. It wasn't about a subject. It wasn't about just this little thing. It's about us. It's about our country. And to encourage them to remain hopeful despite what they have seen, to remain idealists despite what they have seen and what has happened. Because in these jobs, a lot of negativity comes in, but you've got to, that's a lesson, again, as I mentioned, I learned from General Meese. that you somehow, you keep it together and you present you say, look, I know I'm experienced, I've seen how the sausage is made, but this ideal, that's all we have left, is this wonderful ideal of what the perfectibility of this great republic. And so that's basically the reason. I mean, and plus it's kind of fun. I mean,
Well, and you can contemplate, I suppose, about how our country would have gone in a completely different direction.
well, yeah, if
That
we'd
turned out
lost. I mean, if
differently.
Lee had won, that'd have been a problem.
That's right.
And it'd have been
yes,
more
it
of a
would.
problem for me than you.
That's probably so. Well, so let's stick with reflections. Reflections on the last 25
Yeah,
years,
well,
not
I like
100
air
and some odd years
conditioning too
ago.
much to have lost.
So, and perhaps you'll mention your maritime opinion. You know, so opinions that you've written over the years. I mean, I remember the first time I read an opinion of yours that just captured me. It was a 1999 opinion. It was a City of Chicago versus Morales, in which the court struck down an anti-loitering, really an anti-gang ordinance, and you wrote this passionate dissent about saying, for the supposed right to loiter of the 2%, you were condemning 98% of the residents to have to be behind. And that just hit me and has stuck with me. I'm curious, what opinions over the course of your career have stuck with you as having been ones you're most proud of or most profound?
I don't know. I think there are ones that there are different types of opinions. I don't really see them as trophies. I don't think about them when I'm done. I think about, there are opinions that I think about. They're usually ones that are really hard. The Bettis opinion, really I agonized over and then agonized throughout the summer on again, that was she lost her car. The government took her car and her husband's car because he was visiting a prostitute.
Right.
That really bothered me a lot. The cases like the Haitian refugees, cases where your heart goes one way, but you've got to stick with the law. Those are really hard opinions, and I think those are the ones that you think a lot about. The ones where those are the ones where your hair begins to fall out. But the one you mentioned, Morales, the thing that concerned me was I think sometimes we write these opinions, or the court decides cases, and that case, that was about keeping gangs off the street so that poor inner city people could walk down the street. Little kids could go to school. I lived in the inner city. And you imprison people if they're not capable of using, whether it's public transportation or public streets. And I think sometimes because we don't have a sense of that neighborhood, we don't point out that side of the equation. So that was just a paragraph or so of the opinion, but I was just making that point at the end after you went through the vagueness analysis, et cetera. But I don't really go back and sort of look at specific opinions. I look at things that I need to do more work on. I look at opinions that, for example, if I have to, I taught a course on stare decisis and spent about a month or so preparing for that simply because people talk about it a lot, and you don't have time during the term to read thousands of pages on that. But the ones where I'm not sure is where I probably agonize over and spend more time on, particularly during the summers.
So we'll get to stare decisis a little later. Do you spend more time agonizing over the opinions in which you're trying to command a majority, or about the ones in which, say, you're a lone dissenter? And how do you work that in terms of moderating your position, if you do, in order to try to bring more of your fellow justices along to join an opinion of yours?
I think I don't really have a problem writing majority opinions. I mean, I rarely have problems with that. You're an agent for the majority when you're writing for the majority, and I don't try to. One of the things you learn at the court over time is that everybody knows everybody. And if you're an honest broker when you're writing for the majority, you really don't have a problem. So I really have never had a problem with that. I mean, any number of opinions that start out fractured, 5-4 or 4-4-1 or something like that, that wind up 8-1 or 7-2. So that's not a problem. But you agonize over it if it's a technical opinion. You take something like the whether or not you can patent the breast cancer gene. I mean, yeah, that's technical, so that's difficult. But it's difficult in a different way from, say, the Haitian refugee case. So of course you have to spend a lot of time on it. But I don't agonize over it. I said, oh my gosh, how did I get this one? But there are tax opinions that you might be complicated, but you don't lose a lot of emotional energy over a tax case.
Well, but I was really curious, say in constitutional cases, when you're trying to get some of your fellow justices to join your opinion and see things your way,
I really
how much will you moderate?
A lot of time on that.
Okay, okay. So you're going to express your view on and whether others join you or not is.
If we agreed, and I'm writing for the majority, yes, I write a little more narrowly, a little more crisply, because someone doesn't want to go quite as far. But you don't change the principle. For example, you might compromise and not go as far to hold the court. You do that sometimes. But you don't change your underlying view or your underlying principle. I never do that. I haven't done that in 25 years. That doesn't mean that I don't make a mistake, but I don't believe in doing that. So when you write separately, I try to be thoughtful. I mean, even if you go back and you take a look, is when I wrote separately in the McDonald case. I would love to have been in the majority there, but I still believe we should not ignore the Privileges or Immunities Clause. And so we spent an enormous amount of time explaining the history of the Privilege or Immunities Clause and what it included. And I'm not saying that I had it perfectly or anything like that, but we did a ton of work on it. You don't just throw it out. We did it a few years ago. We did three opinions in the administrative law area, which I think is very important. And that was quite a haul because you were trying to show the implications of what we had been doing. And it took a lot of extra work, simply because I think you owe it to people that when you're breaking new ground that you have to explain things more thoroughly and more in depth.
Yeah. But certainly with respect to McDonald, we can talk a little bit more about privileges or immunities in a bit, and certainly with respect to the administrative law decisions, which you've been talking about, your bold positions with respect to the vesting clauses. You've been quite out front and quite bold, and I applaud you for that. Well, one thing that I know that's on the mind of really everybody in here is still absorbing the impact of the passing of your good friend Justice Antonin Scalia last February, and I'm just curious whether you could perhaps share some, fond reminiscences of your time with him, either on or off the court.
I did not know Justice Scalia before I got to the court. I had not met him. I had one law clerk, my first law clerk, Chris Landau, who had clerked for him. And so he snuck me in his chambers when he wasn't in one time. And that was really the most extensive time I'd ever been at the court before I became a member of the court. But when I got to the court, Justice Scalia made it a point. He has this reputation of being this sort of tough, I think unfairly treated as being aggressive in some ways. I never found that side. We might disagree on something, but it was always very, very warm and very cordial. It's also enormously respectful. From the first days I was there to the last days. Our relationship was not one. I mean, I didn't go to the Kennedy Center to see operas with him. And I used to kid him about that. I said, Nino, I like opera. I just don't want to be around the people who like opera. He always thought that was really funny. And he always thought it was really odd that I was from the South but wouldn't go hunting. And I thought it was really odd that he was from New York and New Jersey, and he went hunting. But he would try to talk me into that, and I told him there was no good comes from being in the woods. But it was absolutely delightful. I would go in his office, and we would just literally most of the time was just laughing. Sometimes he'd be a little down, and I'd try to boost him a little bit and get him going. And one of the funny things toward the end was we were on opposite sides. He was really pretty aggressive with that Fourth Amendment. And so we were on opposite sides again in a Fourth Amendment case. And I think it was an anonymous tip about a drunk driver. And I forget which one. It might have been the DNA case. I can't remember which. But in his opinion, as a dissent, he said that this is a liberty-destroying cocktail. Yeah, I said, that's a good line. And I said, Nino, so you think my opinion is a liberty-destroying cocktail? Yeah. So at the end of the term, we went to lunch. And it was the last lunch we went to as two chambers. It's really a tradition we started early on. And he was there, and he's ordering, and he's trying to figure out now what kind of a cocktail do I have before lunch? I said, Nino, how about a liberty-destroying cocktail? Oh, you thought that was hilarious. So, but one of my favorites is Nino, of course, was a constitutional law expert and he loved talking. And I think he must have thought I was just a wrecking ball or something, but he loved administrative law, I'm sorry.
Right.
And so we were sitting on the bench one day, and I would only say this because he is, it's just really, but he leans over to me, he said, Clarence, our, A-U-E-R, our is one of the worst opinions in the history of this country. Yeah, Nino, yeah, you wrote it. Which is, oh my goodness, he couldn't remember what he had done. But
30 years is 30 years.
But I trusted him, and we trusted each other. Even when we disagreed, if I told him I didn't agree with him, he trusted that I didn't agree with him. If he was on the other side and he had an edit, he'd call me up, and he had a concern, I trusted him. And I didn't have to look for where he was. I didn't have to talk to him. We almost never talked about cases before we voted. It was very rare. But we would almost invariably, for slightly different reasons, wind up on the same side. And he always thought it was really hilarious. He said, how did you wind up in the same position? You're from down here. You come from a barely literate family. His father was like a romance literature professor. And I said, for some reason, he was from the north, I was from the south, but we wound up at the same place. But it was just, I can honestly tell you I miss him.
Well, that was one of the points I remember he made in his dissent, I guess, in perhaps it was Obergefell, in which he said, that there's a lot, if we're going to make policy decisions between the court, that then regional variation, all that stuff really matters. But of course, if you're going about the task of actually being a judge and interpreting the law in a consistent way, that sort of regional variation shouldn't really matter.
He tried very, very hard, in my opinion, to always be open to disagreements, concerns. He always cared about the big things, the principles, the small things like syntax and vocabulary and punctuation. I would go by to see him, and he's got his rack of books there, and he is booking his opinions. He's going through them. He did the small, he did the big, and he cared about it all. So, and that teaches you a lesson that it all matters. So after he'd passed away, the course of it is horrible. It was just horrible in every way. I normally left the bench right after him, and his office, his chambers were next to mine, so I would be a few steps behind him because I left later, and I would catch up to him and we'd talk a bit, usually just sort of about nothing, yucking it up. And the first day he was gone, I caught myself coming off the bench, taking a quick step to try to catch him. And that was the poignant example of someone who's missing, that he's not there. I mean, there's nobody to catch up to. But he was, for me, a fun guy. I mean, I would often just go in, and it was not about cases. It was just to talk. And sometimes if one of his clerks told me he was down a little bit, I'd go in and we'd laugh, and then you leave, and hopefully he felt a little better. You know?
Well, obviously, your respect was and admiration for each other was quite mutual. Well, in light of this current vacancy, one of these days we're going to have another confirmation hearing, and there are a lot of people who, of course, believe that the confirmation process is broken. Your confirmation being one example of that, and I'm curious your thoughts on whether there's any hope to improve the confirmation process.
There's always hope, but this city is broken in some ways. I've been here now most of my life now, and I think that we have become very comfortable with not thinking things through and debating things. That's one of the things I love about the court. You can actually talk to people about things. And I think that we have decided that rather than confront the disagreements and the differences of opinions, we'll just simply annihilate the person who disagrees with me. I don't think that's going to work. I don't think that's going to work in a republic or in a civil society. And at some point, we have got to recognize that we're destroying our institutions and we're undermining our institutions. And we're going to destroy them, but the day's going to come, if it's not already here, when we need the institutions and the integrity of the institutions. So even when you disagree with people, if you notice in my opinions, I don't attack personally my colleagues. I disagree with them strongly because I think it's important for me to leave them standing and to leave the institution standing and to sharply have the contrasts and the points of view. But I don't think that's going to change in the city until we get back to sort of a notion that we argue, that we debate, that we decide things based on logic and facts and reasons, as opposed to who yells the loudest or who has the best narrative or best meme or some other nonsense.
Well, let me build on that a little bit. So obviously there are a lot of people in this country who believe that the presidency and Congress is sort of irretrievably broken. They've just lost confidence in those institutions. There are a lot of people that have lost confidence in the courts, including your court, and really sort of view it as just being just another political branch. What do you say to people who believe that?
I'd probably say more to us. What have we done to gain their confidence? And I don't think people owe us reflexively confidence. I think it's something we earn, and that you try to do your job in a way that they can have confidence in what you do. You try to do the hard things that they shouldn't be doing in a way that they can have confidence in, that you can trust. And perhaps we should ask ourselves what we have done to not earn it or to earn it. And I'm not so sure I have all the answers to that. But one of the things I tell my clerks, you simply try to live up to the oath you took. You took an oath to show fidelity to the Constitution, you live up to it. You took an oath to judge people impartially, you live up to it. That's in this city, that doesn't go for much. You take heat for it or whatever, but That's part of the job. You're supposed to be beaten for it. You're supposed to do your job. And so hopefully someone that will run up to you one day with your Federal Maritime Commission opinion and have a lot of confidence. And he's shaking it. This is what this is all about. So, and that doesn't sound like a whole lot. Nobody cares. I mean, probably most people don't even care about it. But it does mean something to you when an average citizen has confidence that you did your job fairly, you did it right, as best you could. And he didn't say he agreed with me.
Right.
He said he could understand it, and he accepted it because of that.
Well, certainly you and Justice Scalia and some of your colleagues, when you think the court has issued a political opinion, will call them out for that. Do you think that there's a hope of sort of reining that in? Do you hope that perhaps your colleagues over time will be persuaded, or what do you hope to gain by putting that out?
Oh, I don't know. I mean, I think that, you know, if you're going to do substantive due process, you run the risk of broad policy decisions. You tend to stray far afield from law. And what Justice Scalia was saying is that you've got to have rules. It's got to do some work. You know, nobody's really that interested in it, but that's part of the reasons I dissented in the commercial speech cases, you know, and the Central Hudson test. You know, it's a multi-factor, 4-factor test that always takes you where you want to go.
Right.
You know, well, that's not much of a test.
Right.
And I think that Justice Scalia understood, whether it was the Lemon test or even the Central Hudson test, that we have got to have something with more teeth to it, with more grip to it, than that sort of a test. And that's the problem with substantive due process. And these leave rooms for you to come out where you want to go as a policy preference. And I think so. I don't know whether it's totally people are political in the sense of the politics of the city, but the jurisprudence allows for it. It allows for that criticism. I mean, we took criticism in, let's say, in Bush v. Gore or something like that. People can easily throw out and cast aspersions about a particular opinion here or there. But I think what you try to do is you do your job in a way where you know that you have applied the law in a fair way. You know, some years ago, a court that I really enjoyed being on was the one that was when the composition that was together for over 11 years with Justice Souter and O'Connor and Stevens. We were together a long time. And one of the things that one of my colleagues with whom I rarely agreed said, Clarence, you are consistent. And I think that is, whether you're baseball or a referee in basketball, call it the same way. Just call it the same way for both sides, and you can live with that.
Now, like the maritime guy, he wasn't necessarily paying you a compliment when he said that
yeah,
either.
But he could understand.
He may not have agreed with you, but he appreciated
But
what
he
you
never
were doing.
said he agreed.
Right. No, I get it. Well, so I want to talk a little bit about certain provisions. You just made reference to substantive due process. Before I do that, I want to take a slightly broader view. You said that the Constitution is not a standalone document, and that it can really only be properly understood in combination with the Declaration of Independence. And I wonder whether you could elaborate on that a little bit.
You know, my point was that we have to understand why this. This was a question I was trying to answer in the mid-1980s. Why this government? Why this republic? Why isn't it something else? Why didn't we do what the French did? You know, and so I had to start with the Declaration. You know, government by consent, inalienable rights, et cetera. And what were we protecting with the structure in our Constitution? And I think when you look at the Constitution, which is the positive document, with a Declaration as a backdrop, you understand why this republic. Why is separation of powers so important? Why is federalism so important? Why are enumerated powers so important? Why a written Constitution? Why is it so important? Because they're certain you gave up some of your rights in order to be governed, not all of them. And it's that limitation, the protection of that liberty. You know, I went back, I read a lot of Justice Scalia's separation of powers opinions this summer. And they all seem to come back to one theme: protecting individual liberty. It wasn't just to have separation of powers. It wasn't just to have federalism. It wasn't just to have enumerated powers. It was you had these in order to protect liberty. But where does that start? It starts in the Declaration.
Yeah, so I always find it frustrating that people will talk about the Bill of Rights as if that's the cake, as opposed to, these were 10 amendments to the actual document that was our Charter of Freedom, that we, the people, were going to consent to be governed by this. And they ignore those structural protections are what really gave us liberty.
It's really interesting. I did not fully understand that until, again, sitting at EEOC in the 1980s with Ken Masugi and John Marini. I certainly didn't get it from law school, because the amendments were a big deal in law school, and we didn't even read the Constitution in full. But I think the structure is so important. And perhaps that's where, on the constitutional issues, perhaps that's where Justice Scalia and I saw eye to eye from the very beginning, the critical importance of the structure. The other thing was that the text. This is a written Constitution. This isn't common law. This isn't like we will make it up as we go along with common law, where you have to have the stare decisis has to lock it down. You have a written document. You have written amendments, which are really important because it's again, a positive document. So I think that the structure is important, the most important part of it. The limitations built into that structure are critically important. And that's why you see, for example, that I would write extensively on the Commerce Clause. Look what you're doing. You're eviscerating the relationship, what the national government can do. This is an enumerated power. And if you expand that, if you go from regulating commerce to economic effects, or effects on commerce or whatever. That's a quite different test from regulating commerce.
Well, you just touched on sort of revisiting past precedents, stare decisis. I'll get to that in a moment. I want to lead, though, so you've talked a little bit about privileges or immunities. You've made some statements about substantive due process. So when you look at different clauses in terms of protecting personal liberties, economic liberties, which clauses do you sort of gravitate to? Due process clause, equal protection clause, the privileges or immunities clause, or what other provisions?
Whatever's in the Constitution. I mean, it's all there. The Bill of Attainder there. The Third Amendment's there that we skip over. The Second Amendment we want to pretend doesn't exist. The First Amendment has, Congress shall make no law respecting the establishment of religion. What is the establishment of religion? It doesn't have like wall of separation. Right. It has establishment of religion. So you go back to the language. What does it mean? And we're obligated to do that. We're absolutely obligated. Or people's theories. I think Judge Brown gave a lecture on that about these theories. These theories can spin off in a totally different direction from the limitations built into the Constitution itself. And I think that's quite important.
All right. So that's great. So you talked about limited enumerated powers for government, the structural protections. You've mentioned how the privileges or immunities clause has been perhaps ignored, even though it's right there. So let's talk about your view of stare decisis. So you have been both praised and criticized, depending on which side of the aisle you happen to be on, for being perhaps more willing than some of your colleagues to revisit past precedent. And this isn't unique. I mean, sometimes the court has, whenever it's deemed it appropriate over the course of its history, revisited preferences in some, precedent in some way. Mm-hmm. But I'm curious to sort of hear your views on stare decisis, on these constitutional questions, and how would you respond to your critics about this?
I don't really care.
Okay, let's set aside the last part of that.
Stare decisis I care about. The criticism I don't. So that's why I taught this summer. I mean, I read everything I could get my hands on stare decisis. And the theory is all over the place. I mean, Justice Goldberg's theory was basically, the it's a ratchet, as you improve civil liberties, those strict rules of stare decisis apply when you win those cases. But when they need to overrule cases in order to do what he thinks is the right thing, then a loose set rules of stare decisis apply. Then you get Brandeis. He has his rules on stare decisis. But he overruled Swift v. Tyson, which was a 96-year-old precedent. Then what do you do with Plessy what do you do with Plessy? When you get Brown. So you've got lots of precedents out there that have been changed. Or what you have Justice Brennan redoing the political question doctrine in Baker v. Carr. I'm not saying he overruled anything, but boy, it didn't look like it used to look. And but the point is that they change a lot of things, and when people get what they want, then they start yelling stare decisis, as though that is supposed to stop you. That's like boogeyman or something. I think that the Constitution itself, the written document, is the ultimate stare decisis, that it is written. So Caleb Nelson has, I think, a nice piece. I'm not saying it's totally right, but Caleb's very thoughtful on stare decisis, and he makes a point. If you have a choice between two, if the statute allows you to choose between A and B, and you would on a clean slate choose B, but the court's already chosen A, that you give that stare decisis because the choices were there. The court's chosen, you don't change it. But if the court has chosen C when the statute gave you A and B, then that is clearly erroneous. Everybody thinks that does not deserve stare decisis effect. But now let's just apply it to something else. Let's do substantive due process now. You get people saying constantly, I think that what we have done, let's say, the Slaughterhouse case on privilege of immunity clause. Slaughterhouse case is wrongly decided. Well, my point in McDonald wasn't I had the answer. I didn't say that. I said if everybody agrees it's wrongly decided, then why are we applying it? That's it. As simple as that. And I think we have to do more than like just zip up. We have to just say, we're not applying it for these reasons. Well, stare decisis, it leaves you wanting an explanation.
Right.
So I wasn't trying to grandstand or anything, and that goes back to my FMC guy, that we owe him an explanation. Even if you come out the other way, you owe him an explanation. We all agree Slaughterhouse is wrongly decided. It has had a profound effect on this country. And you know it and I know it, that when you guarantee citizenship to people, the privileges or immunities of citizenship that cannot be impinged upon, and then you read it out of the Constitution, or you trivialize it, or you minimize it. If I said to you, okay, I said, John, you're a member of my club. You have all the privileges or immunities of membership in this club. Then I rewrite the privileges or immunities to mean you get to ride the elevator once a week and that's it. You said, boy, that's a heck of a membership. Everybody else is swimming and they're in the gym, etc. They're in the sauna, and I just get to ride the elevator once. That's the way I feel about the privileges or immunities clause. And as I said to you about the battle at Gettysburg, I have a personal interest in this. And I've always thought, I lived under segregation. And we talk about all around these things. This is at the very heart of it. Go back to Dred Scott. Here you have Tawney. What did he say? That no black could be a citizen for the purpose of diversity jurisdiction. And he goes on and on and on about the other stuff, the Kansas-Nebraska Act, etc. Now, the 13th, 14th, particularly the 14th Amendment, answered his question. It guaranteed that citizenship and all the privileges and immunities of citizenship. And then we sit here and we read it out of the Constitution. So anyway, you said, why do you get passionate about it? It is the heart and soul. It's not just a subject. It's not just a theory. It is what makes it all work. It was a way to perfect a big blemish on this country's history. That is the blemish of slavery. It was the big contradiction, and we fought a war over it.
You know, so it's interesting your approach to stare decisis. So it really is sort of once you get what you want, it's a one-way ratchet. You get what you want, and then all of a sudden it becomes settled law, which ought not to be revisited. And
if I were on the Court of Appeals or the district court, then I have to apply the precedent. And I did that when I was, for the 2 minutes I was on the DC circuit. And I would do that. I would faithfully do that. But we are in a different place. And I believe we are obligated to think things through constantly, to re-examine ourselves, to go back over turf we've already plowed, to think it through, to like torment yourself to make sure you're right.
you made reference before to the fact that you used to have 4 cases that you would hear a day. So I mean, the court used to hear 140, 150 cases. Now you hear about 70. How did this come to be? And is this a positive development or a negative development? What are your thoughts about that?
Oh, I guess it's, well, if you think they're rightly decided, it's a positive development. Or actually, if you think that we have been wrongly deciding cases, it's a positive development. You know, I don't know. Everyone comes to the court thinking that there are more cases to grant cert in. And then we wind up doing exactly what we were doing before. When I got to the court, it was close to 120 cases or so. And that was a lot. And the court had been doing 150 or so at some point. I think around 110 or so would be good, 100 to 110. But I don't see any prospects with our discretionary jurisdiction that that's going to happen anytime soon. Also, take this into consideration. Other than the health care, the Affordable Care Act, which seems like it's kind of a misnomer considering all the things that are going on. The Affordable Care Act was one of the last pieces of major legislation, one of the few pieces of major legislation. So it's not like you have a lot of that. Where the real action is, the activity legislatively occurs is actually in the agencies, right, in the administrative agencies. So I don't know if there's that much legislation that's actually going on that requires review. When I first got to the court, we still had the new bankruptcy code, and we had quite a few of those cases. At one point, we got a new EDPA, was in the criminal area, so we had a ton of litigation there. And what we're doing with in the area of criminal law and the collateral review, which is God only knows what. But I think you're going to get a lot of review in the lower courts on that. But there's not been major legislation, and so I don't know what the source of the litigation would be. The other thing is that a lot of and I don't know the total impact of this, but a lot of the cases are being siphoned off or being diverted to mediation or arbitration. And we have a very light review of that under the Federal Arbitration Act. So they're not coming up like just the normal commercial litigation through the federal court system. Right. They're like off to the side. And I think that may be a cost consideration for the companies that are engaged in this.
And so you were mentioning before about there's very little legislation, and regardless of whether you happen to like the Affordable Care Act or don't like the Affordable Care Act, I think it's bad. I know, I understand that. It's certainly bad for the country that was done on such a one-sided basis.
Remember John said that. I didn't say that.
I totally get that. But one interesting point is that obviously that legislation and many other bills that pass when they pass do exactly what you just said, which is they said, here's, I'm going to empower some agency to go out and do good. Basically, they give some nebulous direction, and the agencies are often effectively performing, or I'll ask you, legislative function. Then they're executing those. They're performing an executive function. They then often act as tribunals, so they're performing a judicial function. How do you approach those sorts of cases when you're trying to interpret law and figure out, where the line is? You made reference to Justice Scalia's statement about how do you approach those cases sort of differently when you're thinking about taking them up and deciding?
I do my job. I don't, to be honest with you, I think if a case is cert worthy, you take it. That if there's a split, there's a big issue, it's preserved, you take the case. I don't get into we may not win this or anything. That's not my job. My job is to decide cases of controversies. The administrative law area is obviously complicated, but it's our job. And it's complicated by things like Chevron. It's complicated by our willingness to say, oh, let the expert agency decide, and then give them all this running room. More running room, by the way, than we would give an Article III judge.
Oh, right.
So I think it is, and you know that I've written extensively in these areas, and it isn't because I had any axe to grind. I did not have an axe to grind. But I do think that when we don't review things, we abdicate our responsibilities. We are required, there are checks and balances in our system. A part of the check from the judicial standpoint is the review, the cases. You don't review cases when you say, oh, we defer to virtually anything the agency does. That's not a review. We don't do that to a district judge. And district judges are Article III judges. They have the same status and courts of appeals have the exact same status we have. But we do that to the agencies. So I think we are, and I've written again on this, I think that as just a constitutional matter, we are obligated to be more exacting in our review. That doesn't mean you don't show them some deference, but I think we're obligated to do more than just wave our hands at it and say, well, Chevron, and be done with it. That's no review at all.
How helpful do you find amicus briefs?
Which ones?
Well, I'll leave it to you. So do you read all the amicus briefs in all the cases? How do you sort of go about picking? Well, how do you, so this particular party?
I mean, if you have 30 amicus
yeah, no,
briefs,
it's huge.
Yeah, there are people who are credible. The ACLU, for example, is credible. You find people that you may not agree with what they say, but they're good. So that's a good brief you should read. The U.S. government, you read that. You read the briefs of states if it's something that they say 10 states are writing something. But some people, like law professors for a better world. That one doesn't just sort of run, that's sort of like one-off kind of group. I mean, you might go through it,
right.
But they start out with some polemic or something like that. There was an excellent amicus brief we had by electrical engineers supporting neither party. And it had to do with a grid. They were explaining an electrical grid. And I just thought it was just excellent because I didn't know what the heck a grid was, and neither party was explaining it. And so these engineers actually helped the court. They were friends of the court. You run across these in technical cases too. It might be the sort of intellectual property group might explain, say, a technical patent area, and then that is a good brief.
That's a good. Thank heaven.
Yeah, but there are. I think for me, a brief, if it is thorough, if it is honest, if you can look at that and say this is an honest broker, that this person, you don't agree with that position, but this is honest. This is an honest brief. Then for the repeat people, you read it again.
So,
or if they make a point, a good point, you will read their next brief. But if it's somebody just sort of a one-off, I mean, you don't spend a lot of time with those.
We're nearing
unless
the end
it's
of our
a party.
We're nearing the. Well, I assume you read those briefs. We're nearing the end of our time. I want to step back. So you and Ginny, I gather, go during the summers, and you head off on a bus and you travel the country.
2 days I spent on my bus.
It's a shame.
Yeah,
You got to work it better this summer. But tell us a little bit about that experience. Some of the great experiences you've had. Why you do that, and how does that help revive you?
This, first of all, is a wonderful country, and we fly over most of it. We fly from destination to destination. I had never been to East Tennessee. I grew up in Georgia, and the thing about segregation, and we have it going on with things like political correctness and all sorts of things in our society now, it created fear, that you couldn't talk to each other. You couldn't go anyplace. So the fear in Georgia was I couldn't go to small towns. Like I do that with my mother now. And I wanted to see small towns, to see our country. And now that I can do that without fear, we thought that we would do it. My poor wife she let me do it. And she came along, and we both love it now. And we've got the same bus we've had for 17 years. And this is East Tennessee. Have you ever been to Cadiz Cove, for example? Or have you ever been to Sevierville and Dolly's, what was it, Dollywood? Dollyworld, yeah. What did we go see with the horses? Yeah, it was, but anyway, we've been to a lot of different things. Then we've been out to the west. We like the mountains. We get down to Florida. But most of all, you see the citizens of this country. It is an RV park is very, very democratic with a small d. It is some of everybody there. The people are camping out of the back of a motorcycle, which is really interesting to see. The people, the first time we went, we have a 40-foot coach, and we were next to this little teardrop thing that was about the size of this thing and this table, and we said, this is really embarrassing. And but it's just, there's everybody there. The truck stop, Flying J, pilot that run into people. So it was right after Bush v. Gore. You asked me, this is I love this stuff. I love the bus, I love the diesel stuff, I love the people, the truckers, everybody. I love it all. So I give you just two stories. So Bush v. Gore, which was, whether you know it or not, was a bit controversial, right?
So I'm told.
Oh boy, you were talking about feeling the heat around here. So I had to take my bus down to Florida the week after Bush v. Gore. So I certainly took security with me that time. And so I stopped in Brunswick, Georgia. I shot south of Brunswick, Georgia to refuel at the Flying J. And so I'm like, it's not like a car, you know,
Right.
It's a real professional thing when you do a bus. You got to put your fueling gloves on and look around like you know what the heck you're doing. And so all these 18-wheelers are around, you know, and I'm like, pretending. And this trucker comes up to me and he says, I'm standing out, he says, anybody ever tell you look like Clarence Thomas? And so I said to him, yeah. And he said, I bet it happens all the time, doesn't it? And then he went on about his business. So then we were recently on the road. So all these things happen to you on the road. Oh, God, it's great. Even the breakdowns are great. So we were in Pennsylvania, and the bus, this is a bad thing. You're going up these mountains, endless mountain, that was it. Well, the bus speed was ending. So you get up at the top, the bus was dying. So finally, we pulled into a truck stop, into a Flying J in Pennsylvania after we got out of New York. And we look around, there's these two guys, you know, down in this little mobile van repairing with a half a set of teeth between them. And but they knew how to fix diesel motors, and we were back on the road. That's the kind of thing. And these guys were great. They were great to talk to. I mean, you had to try to figure out some things. But it was absolutely wonderful. Everything about it, I love it. This is a great country. We've done about 40 states and met a lot of people, been a lot of places. And it's freedom for me.
And I assume most of the people don't know who you are. So
Most people don't care.
okay. Well, that's
I
very
think,
refreshing, I would think, for you.
For me it is.
Yeah.
I mean, it's just, and it also tells you that it shows you the constituency for the Constitution. It shows you it's not the city. It's not the people who are doing all the talking and all the prevaricating. It's just a person camping out of the back of his motorcycle who wants to be left alone,
Right.
who wants to enjoy his country, wants to raise his family or her family, and they're just friendly. If you go to an RV park, people wave, they come by. Sometimes they're too friendly. You just want to sit there, and they want to come and chit-chat, and they don't know you from a hill of beans, but they're just friendly. So I think that it has shown me a part of the country that you wouldn't normally see. I would not have seen in Georgia. and I would not see from Washington, D.C., which are two very different perches, but both in their own way limited perches.
That's great. Well, in a moment, I'm going to bring Ed Meese back up here for a special presentation. And then I would actually ask afterwards if the people here in the audience would remain seated for a few moments while Justice Thomas leaves. But I do have to ask you one more question, which is, any chance for a national title for the Nebraska Cornhuskers this year?
Hey.
They're seventh. They're seventh in the
Look,
country.
we will be undefeated until we're robbed.
Perfect answer.
Well, I think we all would agree that we've been treated to a great evening here with Justice Thomas. Justice Thomas, if you would join me here, we have something to present to you first, and that is, this is our Defender of the Constitution Award. We only give one a year, and we don't do it every year unless we have a real defender. But it says, the Honorable Clarence Thomas, Defender of the Constitution Award, the Heritage Foundation, 2016. Congratulations. What I'm about to do ought to be called the Coles to Newcastle Award, because I'm giving you a set of the commentaries on the Constitution written by Joseph Story, which you can add to probably the set you already have it in your office. This is for your home, or even better, for the bus.
Do you mind if I share it with my colleagues?
Very good. Well, I think this might be a better one for the colleagues because it's a short version. But it's called The Familiar Exposition of the Constitution of the United States by Joseph Story, and I have a particular interest in this because I was privileged to write the foreword.
Thank you, Ed.
Thank you.